Our guest here is Ted Gavin. He is the founding partner of Gavin Salmonese, one of the most active turnaround managers and financial advisors in this country. And Ted, we're talking about right now in particular because he is, or within a matter of hours, will be the president-elect of the ABI.
Yes.
Which means that, well, you've been working hard for ABI for years already, so it's only going to get worse. But we very much appreciate the time that you've devoted to it.
Glad to be here.
But Ted, from your vantage point as an FA in all kinds of bankruptcy cases, let me ask you this. How has bankruptcy reorganization changed in the last, let's say, 8 to 10 years?
I think the biggest change in cases has been in the length of time a debtor is in bankruptcy, or more importantly, the lack of time that a debtor is in bankruptcy. We've seen cases go from multi-year restructurings.
Yes, that was back in the good old days, back in the 80s.
Exactly.
When it was easy to make a living being in bankruptcy.
That's right.
That's right.
You could actually work one case for more than a few weeks. But the cases went from multi-year restructurings that really addressed every aspect of a company's operations and balance sheet to a few months, and now they're down to 45 days or less in some cases. You have to wonder what the effect of all of this is, and I think we're seeing one of the problems, which is they may be clearing the balance sheet with an eraser, but they're not fixing the underlying problems in the business.
So they don't fix the business. So that means there could be recidivism, Chapter 22s, 33s. Yes. Well, let me ask you this, Ted. People are not dumb. You know you've got a troubled company. You're only fixing the balance sheet. Why don't they try to fix the business?
It's a good question. One of the key elements for any successful turnaround of a business is having the cash to weather the storm and fund the turnaround process. While you're stabilizing the business and you're controlling cash, you have to be able to fund a turnaround. Often you have companies that simply have no access to that capital, and so the only option is a sale. You have entrenched lenders who simply don't have the tolerance or the capital to continue funding losses in the company in hopes of a successful turnaround. You could have funds, non-traditional lenders, who have a depleted fund and they can't advance any more dollars and they just need an exit. Lender fatigue and lack of capital will doom any company.
Well, reality of life is, if you don't fix a company, chances are very good that there's going to be another problem down the road. Why are people so short-sighted?
It may not be a matter of short-sightedness rather than immediacy, and the parties calling the shots want what they want, and if you're writing the checks, you can often lever that against what happens in the case.
Okay, well, I guess I can see that. I mean, you've got the people at the top of the deck who've arranged it in advance of filing. They know what they want. They want to get it quickly. But isn't there somebody lower down the food chain, either unsecured creditors generally or some class of creditors, that are going to object?
Oh, sure. You can often have objections from unsecured creditors. There are different types of unsecured creditors. You have trade creditors, note holders, employee groups, and they all have differing interests. So, for example...
What about suppliers?
Suppliers are a perfect example. So,
I mean, you would think that a supplier to a particular company is going to be familiar with that industry. They're usually in allied industries.
Absolutely.
So why doesn't the supplier recognize that there was a fundamental problem in the business that wasn't addressed? Why don't suppliers say, whoa, let's slow down, let's spend a few months to try to fix the business? Why don't they do that?
Often, if their choice is a predestined quick sale or objecting, and the objection runs the risk of blowing up the process because the lender simply says, I'm not going to fund any longer, but I'll pull my loan and we can liquidate. The lender may be fine, but that trade creditor, that supplier, may be more interested in having a customer in the future in that debtor rather than fixing the ills of the process right now. And that's where you get into one of the interesting dynamics of the body of unsecured creditors, because different types of creditors may have different interests. The trade may want the customer in the future more than they want the recovery from the instant case.
Yes, I see, because in your typically highly levered case, the unsecured creditors at best are going to get a tip.
That's right.
For a 1, 2, 3%, maybe most.
That's right.
So that's not worth waiting 3 months for, I guess.
It may not be worth waiting for. It certainly may not be worth blowing the company up over if they are so far underwater that their alternative is zero.
Yeah. Well, what about landlords, employees, note holders, people like that? Do they complain? Is anybody going to listen?
They do often complain. Whether or not people listen is a different story. One of the issues that you often have at play is the dynamic in an unsecured creditors committee. You have a trustee that is trying to put together a committee that's representative of the diverse interests of the creditor body for that given debtor.
Yeah.
And that may be some trade, some landlords, some note holders. And and they all want different things out of the case. They all have different needs after the case is over. It's a really skilled attorney who represents a creditors committee and can navigate those rocks to be able to get the entire committee focused on one solution.
So I guess that's a very polite, and I guess accurate way of saying that consolidated creditors committees in some fashion suppress dissent.
They may not suppress dissent, but they may focus the parties on what is really important to them and force that to balance their interests against what they can actually achieve. I think in a lot of cases, if you have particularly sophisticated creditors, such as note holders, they have the rights that they have. If they don't, if they lose a vote on a committee because the majority of the committee decides to take a specific action and they don't like that, they have counsel. They can file their own objections, and they often do.
I see. Well, what about the judges? I know I've heard some judges say that they're concerned about these rapid fire cases, especially when they're told that if you don't approve this within X amount of days, the world's going to end.
Right.
But can we fault the judges for not slowing down this process and looking more carefully whether or not they're really going to meet the feasibility standard and not come back to court?
I liken being a bankruptcy judge to being a very observant, very intelligent person sitting in a dark room, and you're shown the middle 5 minutes of a movie. You don't know what happened before they turn the TV on. You don't know what happened after the TV is off, but you have to make decisions that affect everybody having anything to do with the movie after having seen the middle 5 minutes. The judge only has what's in the record to make their decision. And so if the record is built around this idea that the company is a melting ice cube and the jobs are at risk and the value of the company is at risk and we have to do this now, and there's the lender who is saying on the record, I will pull the money if you add one more day to this 3-week process that I would like to have, then what's the judge to do? They have to follow the same principles that every other judge does. They can only rule based on what the record of the case is.
Mm-hmm. Well, I guess the good news about this is cases may be short, employment may be short for professionals, but it sounds to me like we are laying the foundation for business in the future. I mean, this economy has been doing quite nicely for a very long time. What are we now? 8 years at least into a major financial recovery?
Yes.
So if it turns around, it sounds like we could have a mess.
Well, a couple points of interest and a little bit of customer sluggishness, and we could have another very busy period in restructuring.
Yeah, that's right. Well, I wonder, Ted, do you think there's ever going to be a time when, let's make an analogy. This to me looks like a wagon drawn by a team of 6 horses. Is a wheel ever going to fall off and it's make bankruptcy look bad?
It could certainly happen. Everything exists within its own context. You start throwing a lot of allegations or a lot of problems without the context of those individual cases, and you start painting the entire process with the same brush. I think you run the risk of having people draw conclusions that somehow the process is broken or the people who run the process have somehow failed the system. I think a lot of attention will go to second-guessing judges.
Well, what about the ABI Commission report? Did it address, or were they commissioners aware of this issue with speedy cases?
Absolutely. The commission considered a number of issues, and they tried to come at a solution to that problem from a number of different directions. They certainly recommended a breathing period post-petition, so that the first 60 days of a case would not be an appropriate time for a sale of all of the assets or most of the assets, unless truly extenuating circumstances existed, and that was a high burden to prove that there was a reason to cut the process short. The other issue, particularly with respect to small and medium-sized businesses, was to make bankruptcy more affordable and more accessible, so there was less resistance to using bankruptcy as a remedy, which is what really causes the delay before deciding this is an avenue we should use, let's get into bankruptcy and restructure. Rather than doing that, companies have delayed and delayed and delayed.
Yeah, well, the problem is human nature being what human nature is.
Right.
How do you get people to file bankruptcy soon enough to be able to fix the business when you still have liquidity? I'm not sure how you could legislate to make that happen.
That would be a very difficult hill to climb, and I don't think I know what the answer to that is.
Well, I've had this notion for a while, Ted, that one way you make people file more quickly is a statutory solution. You say that if you have to confirm a plan or sell a business within, say, less than 6 months, the top 5 executives have to give back half of the compensation for the last year.
So that's an interesting idea. I'm going to put my expert witness around breaches of fiduciary duty or management hat on.
Yeah.
That creates an interesting dynamic, because you may have reasons not to file bankruptcy
Right.
that
Everybody
are really
does.
for the good of the company.
That is exactly right.
And then you have executives saying, but I don't want to risk losing all of my pay.
Exactly.
So you now have executives who are making decisions based on their own pecuniary interest that may be to the detriment of some class of stakeholders to the company. It's tough.
But under the current system, they can also, or they're also in that situation right now, because somebody who's coming in to buy the business says, listen, don't worry, you're going to stay in your job, we'll give you a 2-year employment contract, you'll be making $400,000 to $1 million a year with bonus, so don't worry about it. So that's the opposite side of the same nickel.
That's right. I've been in a case recently where a competitor approached the CEO of the debtor through an intermediary and said, hey, you're selling your assets, if you can make sure we get this contract, we're going to make sure you get taken care of. And the executive...
Whoa. Oh, call the U.S. attorney.
To the executive's great credit, he immediately went to his counsel and said, this conversation happened, and here's everybody who was involved in it, and I want them excluded from the process.
Yeah.
So good for him.
Yeah. Well, I don't know, Ted. That's one of my greater worries, is that if we have more than a mild recession, the recidivism could be so great that somebody might write a scathing book and really tar bankruptcy professors everywhere. Not professors, I should say, professionals, I meant to say, unfairly, because the professionals are doing what they're hired to do,
Right.
and they're doing it under proper interpretation of the law, and the judges are interpreting the law. So I don't know who you blame.
This is a story that's been told before. There have been the books that kind of strike at perceived injustices or unfairness in the system. There have been allegations that bankruptcy judges court cases by allowing unreasonably high fees, for example. And every now and then that story gets dragged out, and an empirical look at what's really happening in the world tends to pat that down, because it's just not really supportable. I think as restructuring professionals, and this is one area where the American Bankruptcy Institute really excels, is we as professionals are part of a community. And in everything that we do have to keep in the back of our mind, is this good for the system?
Yep.
And making sure that a nonpartisan organization that is able to bring knowledge and research together for the benefit of the advancement of the profession and the evolution of the profession as a whole really helps move that along.
Well, Ted, that is exactly what you're going to be doing for the next 2 years.
Yes, sir.
And I hope you survive. But we thank you very much, because without your help, this organization won't go anywhere. But we appreciate it. Listen, you be well, don't work too hard, and we'll check in with you again maybe this time next year to see how the process is working out.
I look forward to seeing you next time, Bill.
Thank you, sir.
Great to be here.